those names off that you told me,
Okay,
but he said Nancy Smith Black,
okay.
okay?
Here's Smith right here.
Oh, okay.
Have a seat right there in the back, okay?
We'll do him last,
Okay. Have a seat, Mr. Smith.
All right, ladies and gentlemen, my name is Robin Ramsay. I'm a judge or magistrate for Dane County. I'm an associate judge for the purpose of conducting most of our pretrial processes. So part of my job on most days just to meet with people to tell them of what they've been charged, their rights, and their bond. These are recorded proceedings. I tell you that for a couple of reasons, but they are magistrate arraignments for Thursday, the 18th of November, 2021. It's now about 11:30 a.m. Kind of apologize for the somewhat late start, but again, part of my job is just tell you what you're charged with, make sure you understand all your rights, and tell you how much your bond's going to be. I started saying these are, and I'll emphasize, these are recorded proceedings. They're recorded for a couple of reasons. First and foremost, it's part of our court record. But beyond that, just be careful what you say, because whatever you say might come back to haunt you later on. So again, you want to kind of filter what you say. Other than that, though, of course, the bond is the amount of money that you would need to post with the court or the county before they let you out of jail. Sometimes there are additional conditions or requirements of the bond. That doesn't happen in most cases, but it does happen in some, and I'll go over that individually with you. Those are conditions that are set out separate and apart from any monetary obligations. But for most people, the bond is just the amount of money that you would need to post directly, either pay it in full in cash, or if you want to go through a bondsman, you can, but it's either to pay that money or promise to pay that money in the event that you fail to comply with some condition of bond, or if you fail to appear when you were required to do so. You can post the bonds in cash in full if you have that kind of money. Most people don't. So they go through a bondsman. Bondsman charge percentages, normally between 10 and 25% of the total amounts that I tell you, but it really depends on whatever you can work out of the bondsman. Different bondsmen do charge different rates. So what I would suggest you do, call a friend or family member, tell them you're in the Dayton County Jail, how much bond's going to be, and then let them work on trying to get you out. If you can afford to put the money up in cash in full, you actually save a little bit of money, because then when you come back to court, you'll get to pile that money toward the fine if you're found guilty, or if you're found not guilty, the case dismissed, then you get all that cash back. But again, that's only when you post it in full in cash. Other than that, though, each of you here, or all of us actually, have the same constitutional rights. You first and foremost have the absolute right to remain silent. You do not have to talk to the police or anyone representing the state at all, because anything you say can and probably will be used against you later on. So you want to be careful what you say. If you start to make a statement, and it's kind of unusual to see the agencies want to come down here and talk to you again after arrest, but they could. And if they do come down here or anytime prior to trial, you decide to give them a statement, you can do so. But keep in mind, whatever you say can be used against you. But in addition to that, you have the right to stop or that interview at any time. You don't have to continue to talk if you begin to talk. You have the right to speak with an attorney, to have an attorney present or any questioning, have the attorney represent you at all hearings and particularly at trial. And if you cannot afford to hire your own attorney, Denton County will appoint, pay for an attorney for you, or if it's one from a different county, then that county would appoint, pay for an attorney for you so long as you're truly indigent. Indigent meaning that you don't have a job, source of income, family, friends. You don't have any way by which you think that you can arrange for your attorney to post your bond. So if you're sure you're not going to get your bond posted and you cannot afford to hire your own attorney, if you indicate that on this form here today, then we're going to have you fill out an affidavit to request a court-appointed attorney. Just make sure you fill it out completely and fully. It is a sworn document, so make sure it's truthful, because if it's not, they could actually charge you with a separate offense. But again, put down the information that Denton County needs to see to determine whether or not you're indigent. If the county finds that you are indigent because you don't have a job, source of income, family, friends, don't have any access to any money that might be able to hire you an attorney, or from a practical standpoint, you're not going to be able to get your bond posted. If you indicate that on this form here today, claiming to be indigent, again, we'll start that process. If you're here on a warrant from a different county and you're claiming to be indigent, if you indicate that on this page here today, we're going to notify that county of your claim to be indigent. They'll begin to get their process started. Sometimes the attorneys will actually contact you before you even get transferred there, but for the most part, you won't be talking to your court-appointed attorney if you get one until you're transferred into their custody. If you're here for a felony grade offense and you're unable to post your bond after a reasonable period of time, you can also ask the court to release you without posting bond at an examining trial. It's really kind of a legal process and normally applies only to felonies, only when you have been able to post your bond and only when there's not been an indictment returned against you first. And if you're here for 15 days or more on a charge that is a Class B level offense, 30 days on a Class A misdemeanor, or 90 days on a felony, and the case has still not been filed or presented or announced, the state has not announced ready on that case, you can also ask to be released on a personal bond based upon that information as well. But again, that's 15, 30, and 90-day increments, and typically your attorney will file requests for that release on personal bond. Last but absolutely most importantly, you certainly still have the right to a trial by judge or jury. Just because you're charged and arrested doesn't mean you're guilty. You do have the right to a trial. By posting your bond, you've done nothing other than secure your freedom. You do have to come back for court at a later date and time. The only exception to that trial right would be if you're here on a probation violation, in which case you would still have the right to a hearing to determine whether or not you actually violated your probation, but not a trial. So there are actually a couple of the here that I think are extradition hearings, which are a completely different process that involves people from out of state. So I've decided to try to move those up so we can get you quickly to those states if we can do that. But again, I'll go over that information with you individually. So let me start off with Jonathan Cardwell. Mr. Cardwell, come on up. Or not.
Jonathan Cardwell, stand on the X.
Hello, Mr. Cardwell. You have one charge out of Cook County, charge of evading arrest or detention with a motor vehicle. It's they're saying you failed to appear. So it looks like they jacked that bond up a little bit. Don't know what it was before, but it has a $15,000 bond. Warrant CR 19. God, that's an old case. CR 19-00678. Evading arrest or detention is a felony offense. So $15,000 bond on this charge. Looks like that's the only case we're holding you for. So if you posted the $15,000 here, you can get out from here. Just make sure you show up in Cook County when you're told to do so. If you understand your rights, charge and bond, let me get your signature on that form, just saying you do understand rights, charge and bond. You're not saying you agree with or admit guilt. And do you think that you can arrange for your own attorney or to post your bond?
I was already supposed to have an attorney, Your Honor, and I'm supposed to, this case is already supposed to be set for trial, and my trial date was in November. But when I asked a woman last night that arrested me, I asked her when they had put that warrant out for me, and she said they put the warrant out for me in October for failure to appear and for evading arrest in a motor vehicle, but I had already been set for trial. So.
Do you have an attorney on that case?
Yes, I do.
I would contact your attorney immediately and see if he knows something about some setting that was there. If not, though, he can then go contact the court in Cook County. But right now, there's a warrant confirmation, and you may be correct, but right now, as long as we have that warrant confirmation, there's nothing I can do about it. So let me get your signature there saying that you understand the U.S. Constitution still applies in theory. Actually, in practice as well.
Reported to the panel. Initial here.
And is your attorney one that's appointed for you?
Yes, sir.
All right, then initials in that bottom box where she indicated. We'll notify your attorney, or at least we'll notify the county, and the county notify the attorney. I would call your attorney immediately though and see if there wasn't something else that got messed up. Okay. Alyssa King. Ms. King, you have 2 MTAGs standing for motion to proceed adjudication of guilt. In other words, these are not new cases, not cases you have a right to a trial on, but you do have the right to ask the court to set bail on them, and they are probation violations. First charge, possession of controlled substance. I don't know what the penal group is. I guess it's probably penal group 1, but it's warrant F-18-3403 out of the 362nd District Court in Judge McFarland's court. In charge of lesser included possession of a controlled substance, F-18-3404, 362. Both of them are probation violations. So again, you don't have a right to a trial on the underlying charge, but there might be an explanation as to why you violated some condition of bond. So let me get your signature on that line, just saying you understand that you're being held on those probation violations.
Is there any form of bond?
No.
There is not a bond right now, but do you have an attorney, Ms. King?
I want a court-appointed attorney. I just need, my fiance, he's kidney failure, and he's the only one that relies on me.
Okay, let's.
So I want a bond so I can be able to go do anything, whether it's go to rehab, go to anything to prove that I'm not that kind of person, because I didn't even know I had a warrant put out on my arrest whenever this happened.
Yeah, these were issued
Fine.
on. They were issued about a month ago. So
That's what I found out recently. I didn't have any idea.
yeah, I hate that when it happens. Let's see. Did you have a court appointed attorney before?
I had Rebecca Lively.
And she was court appointed, right?
Yes, and she was amazing, and she could stand up for me and tell you all that I'm not this way.
Okay, we will notify. They typically do appoint the same attorney, so we will notify the courts to appoint, and they'll hopefully notify Ms. Lively. You can reach out to her in the meantime. So let me get your initials in the bottom box saying you understand that currently you have no bond, but perhaps Ms. Lively can go see Judge McFarland and see if he's willing to set a
I
bond.
can't get out today at all.
What?
I can't get out today at all. My babies were waiting on me.
I'll be honest with you, Alyssa. It is possible it could happen today, but it's very rare to see it happen in a single day. We'll contact Ms. Lively, but in the meantime, try to reach out to Rebecca and tell her that you're here and you really
I
need
don't
to
have
bring
her
it up.
number. I have no numbers. I was arrested without my phone, everything.
Okay, Angela, I don't know. I mean, we can't guarantee that she's going to be reappointed, but why don't you go ahead and if you can print out Ms. Lively's contact information. Ms. King, I can't guarantee you that's going to point the same one. They almost always do. So it's probably, but we'll have to get her reappointed for the probation violation, okay? In the meantime, I'll try to get you some contact information so you can try to call and let her know what's going on, okay?
Fine.
Renee Serena, Srinana. How do you pronounce your last name?
Srinana.
Okay. So there's one charge of fraudulent use, possession, identifying information, less than 5 items out of the 462nd District Court. It's currently showing no bond because apparently Judge Breeding is claiming that you didn't show up for court. So there's no bail currently. Again, it's kind of the same situation. It's possible to get a bond posted or set, I'm sorry, but you would need to get the judge of that court to set your bond for you. So it's warrant F-20-1785367, no bond allowed currently. So again, let me get your signature on that line, just saying you understand your rights, your charge, and your bond. Why is she crying outside my door now?
We've sent her back.
She's crying outside my door. Just another day of sunshine here in Denton County. Can y'all hear that? Renee, are you going to be able to get your hire your own attorney? I think we've already appointed Mr. Chris Abel, so we're willing to reappoint him if you need us to do that. Do you need us to notify him?
Yes.
Initials in the bottom box saying that you are claiming to be indigent, and we'll try to get him reappointed. Just don't cry on me.
Can I get his contact number?
Yeah, I'm not really supposed to be. Angela, do you have the time to do that?
Yes, I'll give it to him by the time he goes back down to booking.
Just have a seat for now.
All right, thanks. Tracy Chen. Mr. Chen, one charge of possession controlled substance being group 2, 1 to 4 grams. It's where they're holding your bond to be insufficient. Not sure exactly why, but it's in Judge Shipman's court. So it's warrant F21 50516. So only Judge Shipman can set this bond. So it's currently showing no bond, but it is possible to get a bond set. Typically, bonds being held insufficient because you either got rearrested on a new charge after you posted this bond, or you failed to meet some pretrial evaluation or some other requirement of court. So just saying you understand your charge, your rights, and your bond. Let me get your signature on that form, just saying you do understand that information. And do you have an attorney on this case yet, Mr. Chen?
Yes, sir, Josh Smith.
Okay, and is Mr. Smith court appointed, or did you hire him?
I hired him.
Initials in the top box saying you have your own attorney. Reach out to him immediately so he can try to go see if you can talk to Judge Shipman and get a bond set for you, okay?
Is that possible to do today, sir?
It could happen today. You know, they started this electronic filing system that was supposed to speed everything up. It tends to be, you know, it has to go through so many channels. So the answer is yes, it could happen. I just don't want to build up your hopes. All right, thanks. Jeffrey Kocher. Is it Kocher or Kocher? Okay, either one. So I have one charge of driving while intoxicated, first offense, Class B. So it is a, looks like it is out of Texas Parks and Wildlife, which is kind of unusual. Bond on that is only at 1,000. So bonds run you maybe $150 to $200, typically about $175. Bondsman love credit and debit card, so you can probably make that arrangement. Let me get your signature on that form, just saying you understand your rights, your charge, and your bond, not saying you agree with it. And do you think that you can arrange for that bond once you get a hold of family or friends or a bondsman directly?
Just pay it like out of pocket.
You're saying you have the $1,000 in cash on you?
I mean, not in cash on me, but like in my bank account, yeah.
Okay, well, you probably have to work that out with the bondsman, unless you have a friend that can go to the bank and get all your money out and bring it to you. So, yeah, when you're going to do it in cash on the long run, you save money, but that means $1,000 cash. Actually, the county doesn't take debit cards or credit cards by law. All right, we'll get this on the system, and hopefully you can make arrangements to get your bond posted. So initials in the top box there. Gary Irby. Mr. Irby, one charge of driving while intoxicated, third or more offense. It is out of,
Wrong person.
will the correct Irby please stand up? So one charge driving while intoxicated, third or more. Pretty much the minimum bond on a third or more is at $10,000. So it's bondable. Bonds run you maybe $1,000, and their percentage is normally 10%. So it's usually around $1,000, but it is bondable. Just saying you understand your charge of driving while intoxicated, third or more, your bond at $10,000 and your rights. Let me get your signature on that form, just saying you do understand rights, charge, and bond amount. And do you think that you'll be able to make arrangements for your own bond?
No.
No? You don't have family or friends that can raise maybe $1,000 and get you out? Okay, Well, we'll try to get you court-appointed counsel. Then let me get your initials in the bottom box saying you don't think you're going to bond out and you don't have the money to hire an attorney. Now, one other thing though is if you did bond out, and you don't have to do this right away if you don't bond out right now, but if you did bond out, you would have to have an ignition interlock system installed in your vehicle. So before we move on from that one case, that one sheet, did you give me your signature and your initials saying that you're claiming to be indigent?
Yes, it did.
All right, so the second sheet is a ignition interlock system requirement. State law does require that you have an ignition interlock system installed in your vehicle. Has to be installed within the next week or within, within 7 days. You do need to go by and see Denton County Pretrial Services on or before close of business the following business day after you get out. So if you don't get out today, you don't have to, but as soon as you get out, you have only until the following day to go by and register with Pretrial Services. They'll give you information regarding where you would need to go to get your ignition interlock system installed and go over some of the other requirements. Also, you cannot drive any vehicle that is not equipped with that ignition interlock system. And you must also not consume any alcohol or any drug to which you're not prescribed while you're out on bond. So just saying you understand that additional condition of bond has been imposed. Let me get your signature on the bottom of that sheet saying you understand that information. We'll give you a copy of this when you bond out. Hopefully you'll be able to bond out, but if not, we'll leave this in your property so you'll get it when you leave. Okay. Jessica Dixon. Ms. Dixon, one charge, possession controlled substance, pen group 1. Bond on that's at $1,500, so it's not all that high. Bonds run you maybe $150 to $250, depending on the bondsman, whatever you can work out with them. So it's only $1,500, but without saying you agree with it, just so you understand, charge, possession controlled substance, PG1. PG1 or 1B, bond at $1,500. Let me get your signature there saying you do. And then do you think that you'll be able to hire your own attorney and post your bond?
I can post my own bond. I have the money. I don't.
And let me get your initials in the top box for the time being. You can still come back and ask for a court-appointed attorney when you make your first court appearance. For the current time, if you're not claiming to be indigent, let's get you out on bond. All right, go call and see what you can do on that. Pierre Gardner. Mr. Gardner, let's see. One charge of assault, family violence, impeding breath or circulation. It is a felony grade offense starting out of Prosper. You know, I'm not sure exactly how the district attorney's office is going to look at this one. It's kind of a different case fact-wise. So if you have an attorney, they might be able to get they might get it either filed some other way or perhaps get a dismiss. I don't know, but probably not dismissal. But without saying you agree with the charge, you have a charge of assault, family violence, impeding breath or circulation, which again makes it into a felony. Out of Prosper, warrant 21-608-023. Bonds at $10,000. Again, it is bondable. So bonds run you about $800 to $1,000, typically right at $1,000. It's usually about 10%. So let me get your signature on that line, just saying you understand your rights, your charge, and your bond, not admitting guilt to the charge. And once you get a hold of family or friends, do you think that you can arrange to hire your own attorney to post your bond?
Yes.
Initials in that top box saying you are not claiming to be indigent currently. And then state law does require, I'm not going to order additional conditions of bond. I normally would, which would be far more intrusive and require all sorts of things, including GPS, but I do have to, by law, have to issue a protective order. That protective order says that for the next 61 days, you cannot go within 500 feet of the alleged victim, Khalid Feliciano.
Can I ask a question? He lives with me. That's my son.
I know. That's why I'm a little torn about it, but it's required by state law. How long has he been living there?
He's been living here for a year.
So he's always lived with you, right?
He's my son. That's all I understand is charge. This is domestic battery charge that they're trying to charge me with. And I didn't even give him a statement, so I don't even know how to, but okay.
No, you're right. There are a lot of things they're going to investigate, and that part's entirely true. But
Okay.
they're saying that you choked out your son, is what they're claiming. Whether it's true or not, it's a whole different issue, I suppose. But for the current time, they're saying that you got into a argument with your stepson and you choked him.
That's not even my stepson. That's what I'm saying. That's crazy. This
He's
is my
your-
real life son.
Oh, I guess the officer made that assumption because of his
And then my
level.
thing is, wouldn't it be a conflict of interest to have a protective order in the same house as my child?
Well,
Who
the
didn't even
concept-
file the case?
yes. Well, I mean, it's been, well, let's say it's pre-filed. I mean, it's a charge, and state law does require that if that's a charge and it's an allegation of choking, it requires that for 61 days you remain outside the household. Still your house, you still your stuff inside the house, but you can't go home for 61 days unless you
Where
get
am I supposed to go?
huh?
Where am I supposed to go?
I don't have a good answer for you on that. That's
Can I file an objection to this myself electronically?
yes, but I would be the one that have to consider it. And on top of that, it's requirement state law. It's required under 17092 of the Texas Code of Criminal Procedure. On a charge allegation of that, it is a requirement.
Which is understandable. But again, it's like I said, it'd be different if it's my wife, I understand, or my girlfriend, but it's my son that I live at
I
home.
follow that logic. But
This is the weirdest case. Okay.
I'm trying to understand what you just said. So it's okay with your son, but not with your
I'm
wife.
just saying that for a protective order against my son that lives in my house, you're telling me I can't go home for
Yeah, and
2 months.
I was just saying the same problem is that for husband and wife living in the same house. It's same issue. But either way, this order can be modified. It can be changed, but we're going to set up for a hearing with either your son or your wife or both to participate.
I think that's what we need to do because one, he's 17 years old. He's a minor.
Yes, I noticed. So, just saying that I told you that this order is in place. I'm not saying you agree with it because I can sense you don't. In fact, there's no need to file an objection because I hear your objection, right? I understand what you're telling me, but by state law, Article 17292, Texas Code of Criminal Procedure, it is a mandatory protective order that must be issued. Again, we can modify it with a hearing that the district attorney's office has a right to attend, but we'll have to get that set for a hearing. So for the short term, yeah, you'll need to find somewhere else to stay for at least a week or so before we can get this set up for a hearing. Okay?
Yep.
All right.
And do I need to file a motion to set that hearing up or you guys gonna already set it up?
No, you can
File a
You can
motion?
contact this office, the magistrate court office, and we have a process for making a request for a setting.
Okay.
All right. Alan Garcia?
You've already seen the judge come inside.
Hello, Ms. Garcia. 1, 2, 3, 4, 5 cases. There are two out of Wise County. Wise County warrant CR 79891-3, CR 79890-3. One is for possession of marijuana. It's a VOP, which to me would mean violation of probation. So it has a cash only bond at $5,000. And then a failure to identify violation of probation at $5,000, but it's not cash, which is kind of weird. So one, because they're both violations of probation, for some reason that one court set it as a cash bond on one, but not on the other. So it's $10,000 to Wise County, $5,000 which must be in cash only. But in addition to that, now UNT is charged with some on-view offenses for theft of property, $2,500 to $30,000 at $2,500 bond. Charge of evading arrest or detention by use of vehicle at $5,000 in bond, and charge upon duty upon striking unintended vehicle. In other words, leaving the scene of an accident at $2,500 as well. So that's an additional $10,000 to Denton County. So $10,000 to Wise County, $10,000 to Denton County, but they are all at least bondable, $5,000 of which needs to be in cash. So without saying that you agree with any of these charges, just you understand that information. Let me get your signature on that line saying you do understand your rights, your charge, and your bond. And Mr. Garcia, do you think that you can afford to hire your own attorney both in Wise County and Denton County, or do you need to ask for?
I think I'm gonna say that just time to write out everything out. So I won't be able to afford an attorney right now.
All right, then let me get your initials in that bottom box saying you're asking us to start the court-appointed attorney process. Again, we'll probably have you fill out an affidavit or request for it, but we'll try to get that started, see if we get you an attorney to start working on these. And we will also notify Wise County that you're in need of court-appointed counsel, okay?
I've got a question, Your
What's up?
Honor. I have court tomorrow here in Denton County, right? And,
They can sometimes take you over there. Does your attorney know you're here?
see, that's the thing with my attorney. He filed a motion. I wasn't able to pay him anymore, so he filed a motion to withdraw from the case. So I don't know what has to be done or what.
I would still try to call him and see if you can at least tell him that you're here in jail, so he'll know that you're not. Withdrawal from your case, do you know that's been granted?
I believe so.
Yeah, if he's off, then there's nothing he can do for that. So we'll try to get you a court-appointed attorney. I guess I can try to talk to classifications, tell them that you, which court is it in, do you know?
It's 158, I believe.
Okay, we'll try to let, I guess.
And Mr. Adame was my attorney.
He's a very good attorney.
Yeah.
Yeah, and maybe if classifications knows you have a court date, we'll see if we can do that. But it's hard for me to guarantee they'll do that. Okay.
I just don't want to have any trouble for that.
All right. Thanks.
Sure.
Guillermo Iglesias. Mr. Iglesias have a charge of failure to possess or require license for home improvement. Oh, wow. This is a Louisiana case. And they're willing to extradite on a charge of failure to possess a license for home improvement. I've never seen that.
Yeah, they're making me for work.
They take those housing standards pretty tough there in Louisiana, don't they? And a second count of RES probably means residential construction required by state. Wow. It is out of a county, I can't even pronounce the name, Calcasieu Sheriff's Office, CALCASIEU. And that again is in state of Louisiana. It's their warrant CPSO 2021-012599. Currently showing no bond allowed. Even in Louisiana, they have the same U.S. Constitution. So let me get your signature on there saying you understand that charge and your no bond status currently. And then I'm going to talk to you about some other stuff to try to get you back to Louisiana a little bit quicker. So let me get your signature on that line, and then let's go ahead and ask them for a court-appointed attorney. I'll send this information to them saying you're in need of court-appointed counsel. Do you have an attorney on that Louisiana case?
No, I didn't even know. I didn't even know about that. You know, just
That's wild.
you know, an officer called me like 2 months ago, and he asked me if I had you know, permit for working there, because I was there working when it was Hurricane Laura last year on Lake Charles, and that's, you know, why they give me this, because I was working with no permit.
Why did you get stopped? Did you just have a traffic offense yesterday and they stopped you for that?
Yeah, last night they stopped me for traffic light, and,
Okay.
and I seen that.
Okay. I was just trying to figure out what agency contacted you, because it was our water district police here. So let me get your initials in that bottom box saying you need a court-appointed attorney, your signature on that line, and then I'm going to go over some additional paperwork with you.
Okay,
No, just let him explain those first.
okay.
And are you a citizen of the United States?
Yes, sir. Yes, Your Honor.
Were you originally from Mexico?
Yes, I born in Mexico, but I'm naturalized.
Okay, but you do not need us and you do not want us to contact the Mexican government, is that right?
Yeah, no.
And initials in that box saying, do not contact the Mexican consulate.
Okay.
So the other reason I'm talking to you is this, is you have a right to, prior to your removal from the state of Texas, you can fight extradition, but there are only two things that you can do to fight having to be shipped to Louisiana. One would be that they have the wrong person. They don't have the right Guillermo Cavillo Iglesias. But they're showing your date of birth, because it is Guillermo, and then it's CALVILLO-IGLESIAS. Is that correct?
Yeah, that's my name.
And your date of birth was on April 20th, 1977. Is that right?
That's right. Yes, because like say I talked to an officer from Louisiana like 2 months ago, and he was explaining me, and I told him that I was working there and everything, and he mentioned me a couple of times, but do you have permit for working in Louisiana? I said, well, we're just painting, we're just doing drywall,
Right.
I'm making my living. Why I need a permit for that?
Well,
But he never mentioned me anything about putting me a warrant or anything like that.
yeah, I mean, there are building codes out there now, even in Texas, they have building codes. And if you build without meeting those codes, I've just never seen anyone extradited for it. But so you could fight the fact that they don't have the right person, that you were never in Louisiana, you don't know who they're talking about. That's one thing. The other thing you could fight is that the paperwork is not in proper form. In other words, you could demand the actual issuance of a formal governor's warrant of extradition, and you have the right to have that set before one of our district courts and to have an attorney represent you in Denton County, but only to fight your removal from the state of Texas. You don't have a right to have the case heard here. For one thing, we don't have that law, or not that exact law. So if you wanted us to set you up for a hearing, that could be as much as 90 days from now. And then you would be shipped to Louisiana. But if you want to try to speed that up, then you can waive that extradition hearing and agree for us to notify Louisiana to come get you. We would give them a 10-day notification saying you have 10 days to come pick them up, or give us a very good reason why you cannot. And if they don't come here within 10 days, we'll inquire one more time. And if they don't come get you, then we'll release you. But that's only when you waive the extradition process. So here's my question. Do you want us to set you up for an extradition hearing that could take as much as 90 days, or do you want us to go ahead and notify Louisiana to come pick you up?
Yeah, you can notify Louisiana and come pick me up. Okay. And so that way, if you say if they don't come in 10 days, you guys can release me, right?
And there's if let's say that there was another hurricane and they had a reason why they couldn't get here in 10 days, we could, they might ask us for some additional time, but generally it's not that we don't love you. We just don't want to house and feed you, right? So let me get your signature on 2 pages. There's 1 page saying, I told you about your right to an extradition hearing, your right to court-appointed counsel, your right to demand a formal governor's warrant of extradition. So 1 page says you understand that. And then the 2nd page is saying that you're not asking us to set that up because it would take too much time, that you're asking us to notify Louisiana today that the clock is running and that they need to come pick you up.
Yes, sir. Yes,
All right. So if you gave me your signature on that, we'll get this over to our extradition unit. They will let Louisiana know that they have limited time to come pick you up. And hopefully we can get that resolved. Okay.
Thank you, yes, for sure.
All right. So hopefully they'll get over here and pick you up and you can go see beautiful Louisiana again.
Absolutely.
Eddie London. Mr. London, they have you here on charge probation violation out of Clay County, Missouri. Seems like we have a number of them out of Clay. What city is in Clay County?
Yes, in Missouri.
Yeah, Missouri said they missed you. They'd love to have you come back, spend some time with them, I guess. It is their warrant. God, it looks like an old one. 14 CY CR 02158-01. So it's showing to be no bond allowed currently, which would be true. Even if they set a bond, you couldn't post it while you're here in Texas. So again, the same thing applies. You certainly still have all your same constitutional rights, even though this is a probation violation. And you even have the right to ask Clay County to get you a court-appointed attorney. So let me get your signature on that first page, which is your notification of the charge, probation violation, burglary, Clay County Sheriff's Office warrant, no bond currently. And then initials in that bottom box if you need us to ask them for a court-appointed attorney, or do you have an attorney up there?
Already have an attorney.
You do?
Yeah,
Is it one you hired?
yes.
Well, then let me get your initials in the top box saying you're not claiming to be indigent. You're going that's also going to help you out, Eddie, because what you can do is call your attorney and see if he can get a bond set. It's called a fugitive bond, but he'll have to get the Clay County courts to do that for you. So we will send this to them. And the other thing is, do you want us to set you up for an extradition hearing, or are you contesting the fact that you are in fact Eddie London, London, born on September 4th, 1991, or are you contesting that the paperwork or basis for pulling you back to the state of Missouri is without cause? Do you want us to set you up for a hearing here? That could take 3 months here, and it usually doesn't apply toward your time when you get there. Or do you want to notify Missouri to come pick you up as soon as they can?
Yeah.
All right, then let me get your signature on the first page saying I told you about your right to court-appointed counsel, your right to have an extradition hearing, and your right to challenge the legal sufficiency of the warrant. And then your signature on the second page saying that you're waiving that hearing and you're asking us to notify Missouri to get down here and get you so you can get this taken care of.
Yes, sir. Do they, I have a question. Do they get up 10 days too? Or say?
Yeah, and again, guys, I want to be clear with you. The 10 days, Denton County, that's what we give them.
Yeah.
If they come up with a very good reason why they can't be here, then we might get additional time and we'll tell you that. But the reason why we hold you is we don't want to hold you for 10 days and have to take care of you and pay, the cost of doing that. If they're not going to come get their people, then we will let you go. But if we do that, that county will reissue their warrants. So it's just a matter of time, right? Okay, we'll tell Clay County that you'd love to come see him in Missouri. Not. And Jeffrey Smith. Mr. Smith, are you feeling a little bit better?
And over here on the end.
Can you stand or do you need to sit down?
Yeah, no, I'm fine.
Okay, I understand you had a bit of a medical issue going on there. Sorry to hear that. But I wanted to go ahead and try to get you done this morning so we can try to get a bond set and get you out of here, okay? So right now you have one charge of driving while intoxicated. It's a first offense, Class B misdemeanor. It's one of the lowest levels. It's one step above a traffic ticket. There is a bond that you would need to post, and the bond's at $1,000, and you could either pay that as $1,000 cash, or if you call a bondsman, they typically run you between $150 and $200 to get you out, okay? You still have all those same constitutional rights. Did you understand those constitutional rights I explained to everyone in the group? Okay. Without saying you agree with it, without admitting that it's true, because it's way too early to do that even if you wanted to, let me get your signature there saying you understand your rights, your charge, and your bond. You're not admitting guilt. You couldn't if you wanted to. And do you think that you can afford to get your bond posted? Okay, once you get a hold of family and friends, you think you can make arrangements to get out today?
Actually, I don't have any family here.
Okay, I'm sorry. If you call a bondsman, you have credit cards, they'll work with you on that as well.
Yeah.
Then let me get your initials in the top box above your signature saying you're not claiming to be.
You're not indigent because you're going to talk about.
All right, we'll try to get this on the system. You can call, see if they can get you out on bond, and then hopefully you'll feel better and you can take care of this case later, okay?
All right, guys, come on. All right, everybody out.
So Angela, do you think I still need to do the PR bond on that guy?
It's up to you, Judge.
Did he look like he was wobbling? I couldn't tell.
Well, he was still having a hard time, writing.
Okay, I tell you what, I'm gonna go ahead and sign the PR bond thing and I'll just.
All right, I'll go and let them know. I'll
Okay.
call Sarge now and let her know.
Okay, that's good.
Okay, thank you. Hey, Sarge, Judge, changed, Smith, he's gonna go ahead and give him $1,000, Judge?
$1,000 PR.
Yeah, the judge is gonna go ahead and give him $1,000 PR bond. Okay. For Smith. Got it. All right, thanks. Bye-bye.
Okay, I signed it in the queue.
Okay, I'll print it out. Thank you, Judge. Thank you, Christina. What's my total, honey? I got,
It's like maybe not.